In the previous video, we studied the 10 essentials of a valid contract. But what is the first step towards building that contract? Hi, I'm Ashik Hanchandani and this is Lawgical Lens. And here we connect law to people one basic at a time. Today, we are decoding the first step towards building the contract, that is, the offer.
What is an offer? Generic meaning: an offer is a proposal made by one party to another expressing a readiness to enter into an agreement on certain terms. If the other party accepts those terms, a contract is formed. For example, A says to B, "I'll sell you my iPad for 10,000." This is an offer. Under Section A, Clause 2 of the Indian Contract Act 1872, when one person signifies to another his willingness to do or abstain from doing anything with a view to obtaining the assent of that person, he is said to make a proposal. Next is kinds of offer. There are 7 kinds of offer. First, express offer, made in clear words spoken or written. Second, implied offer, arises from conduct or circumstances. Third, general offer, made to public at large, anyone can accept. Fourth, specific offer, made to a particular person or group only. Fifth, cross offer, identical offers made by both parties without knowing each other's offer. Sixth, counter offer, a new offer made in response to the original one. Seventh, standing offer, open for acceptance over time or multiple transactions. Essentials of a valid offer. Intention to create legal relationship. The offer must be made with clear intention that, if accepted, it will create legal obligations. Case law: Balfour versus Balfour, where a husband promised to pay his wife monthly allowance but didn't. Court held it was a domestic arrangement not enforceable. Example: let's go out for dinner is not a legal offer. Offer must be certain and not vague. The terms of offer must be clear and unambiguous. Case law: Taylor versus Pottington. The offer lacked clarity, hence invalid. Example: I may sell you my bike for around rupees 50,000. Too vague to be an offer. Communication of offer is mandatory. An offer must be properly communicated to the offeree. One cannot accept an offer they don't know exists. Case law: Lalman Shukla versus Gauri Dutt. Servant unaware of the reward offer, no contract formed. Example: if A offers a reward for finding his dog but B finds it without knowing, B can't claim the reward. Offer can be express or implied. Express offer, made using words spoken or written. Implied offer, derived from actions or conduct. Examples: I will sell my book for rupees 500. Express. A public bus stopping at a bus implies an offer to take passengers, that is implied. Mere declaration of intention is not an offer. Just expressing a future intention or willingness is not an offer. Example: I am planning to sell my house someday is not an offer. Offer can be conditional. An offer can include conditions that must be met by the offeree. Case law: Thompson versus London, Midland and Scottish Railway. It was held a person is bound by terms printed on a ticket even if they haven't read them, provided reasonable notice was given. Example: I'll tutor you if you submit your homework first. Offer cannot presume acceptance. An offer cannot state that silence or inaction will be treated as acceptance. Example: if I don't hear from you, I'll assume you agree. This is invalid. Offer may be specific or general. Specific offer made to a particular person group. General offer made to public at large. Case law: Carlill versus Carbolic Smokeball Company. A reward offer in an ad was considered a valid general offer. For example, whoever finds my lost dog will get rupees 500. That is a valid general offer. Invitation to offer is not an offer. An invitation to offer is not an offer in it itself. It is merely a preliminary communication indicating a willingness to negotiate or receive offers from others. In simpler words, hey, I'm open to offers. You tell me what you are ready to give. It shifts the role to the other party to make the actual offer, which the person issuing the invitation may then accept or reject. Case law Harvey versus Facey. Harvey asked Facey for the lowest price of his property. Facey replied with a price. The court held that the price quote was not an offer, it was an invitation to offer, not showing willingness to be bound. For example, display of goods with price tags in store, job advertisements, auction catalogs or bids, online shopping lists like Amazon and Flipkart. Revocation of the offer. Meaning, revocation means taking back the offer before it is accepted. Section 5 of the Indian Contract Act 1872 says a proposal may be revoked at any time before the communication of its acceptance is complete as against the proposer but not afterwards. When can it be revoked? First, before communication of acceptance is complete. Revocation must reach the offeree before they post send acceptance. Example, or offer to sell a car but revokes before B accepts. Valid. Second, by lapse of time. If no time is mentioned, then after reasonable time. Example, valid till 5 pm is not accepted till 6 pm, it lapses. Third, failure of condition precedent. If conditions attached to the offer are not met. Example, offer says only if you pay rupees 5,000 in advance. Not fulfilled is equal to lapse. Fourth, death or insanity of the offerer. If known to offeree before accepts. Example, A dies and B accepts later. Knowing A is dead, it is not valid. In case if you have missed, here's a recap of offer and contract law. Remember, every contract starts with a valid offer, and now you know exactly what that means.
Got the offer? Great. But an offer means nothing without an acceptance. And that is what exactly we are decoding next. Till then, subscribe and keep learning with Lawgical Lens.